All right, good morning, everyone. Welcome to the appellate court. We're going to be hearing three cases this morning. The first case is State of Connecticut versus Michael Bouvier, AC 42430. The first order of business is to have everyone introduce themselves so that we can make sure that we can all hear and see each other. We'll start with the judges and then counsel. I'm Judge Prescott.
I am Judge Mall.
I'm Judge Suarez.
Good morning, Judges Mull, Prescott, and Suarez. My name is Patrick Tomasowicz, and I represent Michael Bouvier in this case.
Good morning, Your Honors. Felicia Valentino, for the State of Connecticut, Special Deputy Assistant State's Attorney.
Okay, thank you all. You should have received instructions on the rules under which we are conducting this virtual argument on the Microsoft Teams platform. Do you have any questions about those instructions?
I have no questions, Your Honor.
No, Your Honor.
Okay. Important that when you're not addressing the court that you keep your microphone muted, but please keep your camera on at all times, so that's one way that we know that you are still here and participating with us. This argument, I believe, despite these technical difficulties, is being streamed live on the judicial branch's YouTube channel. So I will remind counsel that if there is any protected information that relates to this appeal, that you should avoid mentioning that protected information. I don't think there is in this case, but just please keep that in mind. As always, you both are familiar with our procedures. Each side has 20 minutes for argument. If you're the appellant, you wish to reserve a portion of that 20 minutes for rebuttal time, please let me know. I will hold up a very fancy card when you have 1 minute left in your argument, and I will be keeping the time. With that, I think we are ready to proceed.
Thank you, Your Honor. This isn't a good morning, judges, once again. This is an appeal from a DUI conviction where the defendant was convicted as a third offender, lost his license for life, and was incarcerated for a period of 23 months. This was a case that was hotly contested. There was
Attorney Tomasowicz, do you wish to reserve any rebuttal time?
I'd like to reserve 5 minutes.
Okay.
Thank you, Judge. There was no chemical testing in this case. The defendant performed the one-legged stand for 35 seconds and substantially complied with all field sobriety tests, including the one-legged stand for 35 seconds. 3 rulings of the court have been appealed. 1, the denial of the motion to suppress was harmful error. This issue in the motion to suppress was framed of the circumstances. There must be a scrupulous examination of the record to determine if the factional finding was supported by substantial evidence. That's State versus Azukas 278 Con 267. What is at stake in the motion to suppress is the admissibility of a statement by the defendant that he drank 2 23-ounce beers. Trooper Krinsky testified from the Connecticut State Police at trial that he read the rights, the Miranda warnings, at 1:20 a.m. and the notice of the rights was signed immediately following the reading of them. Then, according to Trooper Krinsky's testimony, in the performance of the post-arrest interview, the defendant allegedly made the statement relating to the amount of beer he consumed. A review of the video evidence demonstrates that this testimony was false. Any forms that were signed in this case on notice of rights or any other forms, according to the video, were not signed until after 2 a.m. Any so-called waiver in this case of Miranda rights is not based upon reliable evidence. The state in its brief does not address this issue of the fact that the video does not line up with Trooper Krinsky's testimony. State does not address this in their brief. Any argument now presented by the state on this subject matter should be considered abandoned. When the issue of whether a conviction was fairly obtained, the criminal justice system suffers when that conviction is based upon a record that is refuted by video evidence. Here, the penalty was incarceration, a lifetime loss of a driver's license, and a felony conviction. Two cases I'd ask the appellate court to look at. State versus Santos. It's a Supreme Court case. In the lower court, a motion to suppress was denied relating to a search and seizure of narcotics. The trooper in the Santos case testified that the defendant was pacing around and perspiring. Upon appeal to the state Supreme Court watched the video, reversed the denial of the motion to suppress, granted the motion to suppress based upon the review of the video evidence that the defendant was not perspiring or pacing back and forth in an athletic field in Willimantic, Connecticut, just prior to the search. Second case that I would bring to the court's attention is Scott versus Harris, a United States Supreme Court case. Justice Scalia authored the majority opinion. A motion for summary judgment was reversed in favor of the plaintiff. It was a police chase case. The plaintiff was rendered a paraplegic. The United States Supreme Court in decision 8-1, upon reviewing the videotape evidence, found that the officer engaging in the pursuit acted reasonably. The motion for summary judgment previously entered in favor of the plaintiff was reversed and granted for the defendant. Here in this case, the point cannot be emphasized enough that the video evidence does not support Trooper Krinsky's testimony. It refutes it. In the memo of decision authored by the trial court on December 21, 2018, the court never addresses the videotape evidence. A motion for a new trial was filed on December 7th, raising this issue. In the memorandum of decision dated December 23, 2018, the judge ignored the arguments raised in the motion for new trial, and this constitutes harmful error. The criminal justice system suffers when convictions are based upon an evidentiary record that is not reliable and refuted by a piece of video evidence in this case that was not addressed by the state during the trial, was not addressed by the defendant during this trial, but was properly raised in a motion for a new trial. This failure to consider the video evidence, which directly refutes and undermines testimony given by a state trooper under oath, undermines any reliability associated with this conviction. Second argument is that the court committed error in permitting Trooper Krinsky to testify, or in the alternative, to instruct the jury that his credibility could be called into question due to deactivating the body microphone that he was wearing in violation of the Connecticut State Police Regulation 13.15.3, parens A, parens 1. What is the setting? The setting is he's out on the roadway. He's off of exit 43 in West Hartford. He had pulled over the defendant. The defendant had been asked to step out of the car. The defendant had been asked to perform field sobriety tests. He substantially complied with the field sobriety test. And then at that point, a backup trooper named Michael Quagliori appeared on the scene, and Trooper Krinsky and Quagliori deactivated their body microphones. They shut them off in violation of the Connecticut State Police Regulation, which said that the body microphones must be on up until the point of enforcement. What is the standard of review in this matter? We say that the motion in limine preventing the officer should have been granted because it was an intentional, deliberate act to turn off the body microphone. Trooper Krinsky did not testify that he forgot to turn off the body microphone, did not testify that it was a mistake. He did it to keep the conversation away from the defense. He did not want it as a part of the record. So under morality.
Attorney Tomasiewicz, did trial counsel for the defendant argue to the jury that the jury should draw an adverse inference against the officer because he turned off the camera?
Yeah, he argued that it should directly reflect on the officer's credibility. But Judge, to your question, yes, but that did not go far enough. In the concurring opinion in State versus Morales, Justice Borden says that an adverse jury instruction can be given. In the Youngblood case, United States versus Youngblood, an adverse jury instruction was given. Even though the U.S. Supreme Court said in Youngblood you have to make a showing of bad faith, which in Morales, that Supreme Court precedent was not followed. Judge, when you're in front of a jury and you're arguing, you can take into consideration the credibility of the police officer due to his actions of shutting off a body microphone. That is vastly different than having a judge instruct a jury that they can take that into consideration, and having a defense lawyer with an exhibit in front of the jury saying, here's the instruction, here's the law. You can follow this law. You are instructed that the credibility of this officer on the totality of his testimony can be taken into account due to an intentional violation of a state police regulation where he turned off a body microphone. So
But
yes.
But your argument on appeal, as I understand it, is that the court should have precluded his testimony altogether.
Or in the alternative, the jury should have been instructed. Either one. And what we're saying is that if the sanction of preclusion goes too far, then the remedy of an instruction was a prophylactic measure which should have been given, because this is the second effort by the police officer. First, we've got the body mic being shut off. Secondly, we've got testimony by him saying at 1:20 a.m., I'm giving him Miranda warnings. He's signing immediately thereafter. That's not happening. We've got the court prior to Mr. Schoenhorn, when Mr. Schoenhorn is making the argument saying, I'm going to give you more leeway on cross-examination to address the fact that the body microphone was turned off. When in fact, what happens on cross-examination, which is my third issue, when Mr. Schoenhorn tries to cross-examine Trooper Krinsky about his testimony being rejected by the magistrate at the Department of Motor Vehicles, it's restricted. So what we're saying, Your Honor, is that an instruction easily could have been provided and to the jury so they could take the credibility of the police officer into question.
Attorney Tomasowicz, when Attorney Schoenhorn argued the motion in limine, did he make the claim that you're making on appeal that in the alternative there should be a jury instruction?
Yes, yes, and yes. And he presented an instruction. He wrote an instruction in the charge conference, which was rejected. So not only do we have Trooper Krinsky, Your Honors, testifying falsely about the timing of the Miranda warnings, but the same trooper is turning off the body mic in violation of 13.15.3A1. And he testifies, it's on page 198 of the appendix, that he deliberately shut off the microphone so any conversation would not be a part of the evidence. Then the court says, I'll give you more leeway on cross with Trooper Krinsky. Then on cross, Mr. Schoenhorn tries to impeach with the Department of Motor Vehicle decision, which says that his testimony was found unreliable under State versus White. And what the court gave in one hand, saying, I'll give you more leeway in cross, the court took away with the other hand during cross-examination.
Would you agree that the standard of review as to whether or not the trial court should have given the adverse jury instruction is an abuse of discretion?
I do, but Your Honor, State versus Daniel G., which I cite in my brief, The court has a duty to provide an instruction when it's relevant to the issues in the case that accurately describes the issues in the case and is a part of the defense. And that did not occur here. And that did not occur here, Judge Prescott, Judge Mall, Judge Suarez, in the setting of a police officer, the second deliberate effort on his part to sabotage what I believe are the defendant's constitutional rights. One is that testimony where he says, 1:20 a.m., I Mirandized him, he signed immediately thereafter. That's refuted by the record. Two, collecting evidence which is potentially exculpatory at that scene. Morales says, the Morales case says it doesn't have to be exculpatory. Morales says that the evidence may be exculpatory. And when we have two troopers on the scene fishing around on whether or not to arrest or not arrest, that was potentially exculpatory. And you have a trooper, when a conviction was obtained in this case with a 23-month jail sentence, lost a license for life, doing two things to directly affect the framework and the structure of this trial. Not to go too far, but the analogy is something is rotten in Denmark. That's what I would say based on this trooper's behavior.
Attorney Tomasiewicz, let me ask you about your last claim for a minute, if I can. I'm not entirely clear what exactly you claim you were trying, your client was trying to get before the jury. Was it the hearing officer's legal conclusion about probable cause, or is it about determination of the officer's credibility?
The latter. And when we look at United States versus White, which is a
Okay.
24.
All right, let me ask you about White. White's a Second Circuit decision. You agree that it's not controlling on this court?
I agree that Second Circuit authority is not controlling.
Okay. And isn't it actually inconsistent with well-established case law? I wrote an opinion, I believe within the last year or two, where someone tried to get admitted before the jury the conclusions of an internal affairs investigation by the police about an officer's credibility. And we concluded in that case, the name slips me, that it simply is not admissible. That's the ultimate question for the jury.
Judge, sometimes evidence needs to be cut with a razor blade. And the evidence which Mr. Schoenhorn tried to get in, ideally, of course, he wanted the decision of the motor vehicle officer to come in, the motor vehicle magistrate. That would be hearsay. The concept of factual findings by another trial, a hearing officer on credibility, you can go too far with hearsay. And I understand the court's concern, but look at White. The White case indicates to us that if there's another judge in another proceeding, and in White, it was a whole same detective, whole different fact pattern. Here, same trooper, same fact pattern. Very simply, Mr. Schoenhorn should have, and he asked to get into evidence, isn't it true that another hearing officer made a finding that your testimony was not accepted? Period. And that's what White seems to permit, where the razor blade is used not to allow a whole subordinate finding to come in on credibility.
All right, Attorney Tomasiewicz, you're out of time, but Judge Mall has a question.
All right, counsel, just very quickly, can you help me understand your position as to the evidence that your client was Mirandized in the cruiser on the way to Troop H?
What we know is he was put in handcuffs. What we know is that he was Mirandized. What we know is that he remained silent. What we know is that when he was Mirandized, he's in a different location. He's not in the barracks. We know there's a period of time that ensues after that. And then there's the claim that I did it again. I did it again at 1:20. He absolutely waived. He absolutely signed. And Judge Dodabo, if you read the transcript, he was very careful. He said, I want to get the sequence of events. You mean you Mirandized at 1:20? I did. And he signed immediately thereafter? He did. That did not happen. So in the car, Judge Mall, once he's in the cruiser, it's a very simple, I've got to read your rights. There was some other discussion, but I've got to read your rights. Boom, boom, boom. The defendant doesn't acknowledge.
All right, thank you.
All right, Attorney Valentino.
Good morning, Your Honors. May it please the court, I am Felicia Valentino, Special Deputy Assistant State's Attorney for the state of Connecticut. There are 3 issues in this case, and I would like to begin with the first issue. The motion to suppress was properly denied because there was an implied waiver of the defendant's right to remain silent. When the defendant signed the form is irrelevant. The state submits that this is an implied waiver case, and therefore it does not matter what time he signed any of the paperwork. The question is, did he impliedly waive his Miranda rights? And the answer is yes. There was evidence presented before the trial court, and that court made factual findings regarding Miranda and the implied waiver. The defendant was read his Miranda rights on 2 separate occasions. He remained silent after the first advisement, and he indicated he understood his rights after the second advisement. He refused a breathalyzer, declined an attorney, and refused to sign the UAR. By parsing between which rights he wanted to invoke, he waived his right to remain silent because he understood and spoke with that understanding. He also has 2 prior DUI convictions and therefore was familiar with the process. The defendant seems to be treating the notice of rights form as a waiver form when it is actually only an acknowledgement that his rights were read to him. Further, any inconsistent testimony as to what time the form was signed is again irrelevant because this is an implied waiver case. Even if it is relevant, the state submits that any inconsistency does not equate to any evidence of falsity, but rather a flawed memory on the part of Trooper Krinsky. Finally, if there wasn't any error in admitting these statements, there was other evidence of intoxication, not only the defendant admitting that he drank 2 23-ounce beers. Trooper Krinsky observed the defendant driving at a high rate of speed, his failure to maintain the lane on the highway, and his failure to stop at the stop sign off of the exit. He also noted an odor of alcohol when he approached the defendant's motor vehicle. He observed bloodshot and glassy eyes, and the defendant failed to perform the field sobriety test to standard. If there are no questions about the first issue, I would like to move on to the second issue. The second issue is the motion to preclude, which was also properly denied because Trooper Krinsky had no legal duty to record his conversation with Trooper Quagliaroli. He turned his microphone off for a stated reason and testified under oath as to what that conversation was about, which was regarding the performance of the field sobriety test, comparing their observations, and to discuss whether or not to tow the defendant's motor vehicle. The entire premise of the defendant's argument is that Trooper Krinsky had a legal duty to keep the audio running and that there was some nefarious reason to not record his conversation. Neither are true. Trooper Krinsky testified under oath to the contents of the conversation, which was approximately 46 seconds long. To the extent that the defendant wanted to explore this on cross-examination, he was given ample opportunity and leeway from the trial court to do so. The trial court, after concluding the hearing, applied the Asherman test. The state would submit that there was no destruction of any evidence in this case, but rather an abundance of caution. Asherman was applied. Even if this court were to find destruction, the factors of Asherman weigh in favor of the state. The conversation was a private conversation between the 2 troopers. It was not material. and we know what that conversation was about because Trooper Krinsky testified to it. It was not likely that the jury misinterpreted the audio recording being turned off because it was for such a short period of time, and the video continued recording so the jury could see exactly what was happening on scene at the motor vehicle stop. Again, there was no bad faith or nefarious reason for turning off the microphone. And finally, there was no prejudice to the defendant because Trooper Krinsky testified and the defendant was granted leeway in his cross-examination. The defendant is not entitled to the private conversation between the troopers. Had this been in an interrogation room, the troopers stepped outside for a moment.
Well, counsel, that seems a bit much to argue that they're not entitled to a private conversation between two officers who are conducting an arrest of the defendant. If that conversation contained exculpatory information, I assume that you would not argue that the defendant is not entitled to the content of that conversation.
If it were exculpatory, he would be entitled to it. But the conversation was that the two troopers agreed on his performance of the field sobriety test and that he was over that he did not perform them to standard and that he was going to be arrested.
Well, that's very convenient to argue because we don't have any evidence of it to the contrary because he turned off his camera.
Your Honor, the state would submit that because Trooper Krinsky was there and under oath testifying, the defendant was allowed to ask exactly what the conversation was about, and he did so. And Trooper Krinsky testified to that, and the state didn't object.
He was deprived of the best evidence that would be available to contradict the recounting of that conversation by the intentional act of the police officer to turn off his video camera.
I missed the first part of what you said. It kind of skipped. I'm sorry.
What I'm saying is that what happened here was that the defendant was deprived of the best evidence that might contradict the officer's recounting of the contents of the conversation.
May I have a moment, Your Honor?
I've never heard of a prosecutor argue that a conversation between two officers at the scene of a criminal incident is a private conversation. I assume that's not what you meant.
From the testimony of the two troopers, this is a common practice where if they're discussing something between themselves, is what the state means by private conversation. It's amongst themselves. It's not with the defendant. They don't record those conversations. Are there any further questions about the second issue? The third issue is the objection, the state's objection to the legal conclusions and factual findings of the DMV hearing being presented before the jury, which was sustained by the trial court. The DMV hearing officer's factual findings were not relevant and invaded the function of the jury in the criminal trial. There was nothing at the hearing that undermined Trooper Krinsky's credibility. He testified consistently at both the hearing and at trial, and just because the hearing officer came to a different conclusion, that had no bearing on Krinsky's credibility. The entire video of the field sobriety test were available and viewed by the jury, so it could make its own determination as to how the defendant performed on the field sobriety test. Again, the hearing officer's conclusions are irrelevant because the video was available and the jury's function was to construe the facts and credit or not credit the officer's testimony. The purpose in attempting to introduce the hearing officer's findings was to show that the jury that reasonable minds can differ as to the defendant's performance of the field sobriety test. The defendant had an expert witness testify to that exact issue and who completely contradicted Trooper Krinsky's findings. Therefore, the hearing factual findings were cumulative. The state would submit that this was not an abuse of discretion by the court and it does not rise to a constitutional violation.
The jury was never asked to determine whether or not there was probable cause to arrest the defendant. Do you agree with that?
The jury does not determine. Correct.
Was not asked to determine that. Do you agree with that? Right? They were asked to determine whether under all of the facts and circumstances of the case, the defendant was intoxicated.
Correct. The defendant was given the opportunity to cross-examine Trooper Krinsky at length, and this limitation was specifically tailored to the factual findings of the Department of Motor Vehicle hearing. Further, I have a moment again, I'm sorry. The state would submit that the defendant was given an opportunity for effective cross-examination, and he is not entitled to cross-examination that is effective in whatever way and to whatever extent he may wish. Also, this case is distinguished from United States versus White. In that case, there was a credibility determination made by a district court judge, which was then not allowed in a second trial before a second district court judge. In this case, there was no credibility determination made as to whether or not Trooper Krinsky was testifying truthfully, and there were no prior inconsistent statements. Therefore, the state would submit that that case is distinguishable from this one. If there are no further questions, the state asks this court to affirm the trial court's judgment of conviction.
Do I have 5 minutes, Your Honor?
Barely.
I'll keep it 4. How long are we going to let the state police enact a regulation? And by the way, the regulation says the audio portion of any statement of a defendant should be preserved, provided all constitutional requirements have been met. They got no audio system in the state police on Washington Street, in that building, apparently. How long are we going to allow regulations of the state police to be aspirational goals and paper tigers versus something that are enforced? You've got a trooper who's not having a private conversation. The only private conversation, that reminds me of the Lyle Lovett song. It's a private conversation. This was a trooper who shut off his mic because he wanted to keep evidence away from the defense. He didn't want it to come into evidence. Now, the criminal justice system gains when there's a conviction that is obtained when constitutional safeguards are protected. It suffers when those constitutional safeguards cannot be reliably ensured that they took place. He shut his mic off. Then when he goes into, we're told now he goes into Troop H and he makes a mistake in his testimony. I can't imagine prior to a criminal trial on a third offender, a trooper isn't watching a video of his interaction with the defendant and knows at 1:20 there's no documentation that anything was signed, and he's not in front of the video camera as he testified reading from a rights card. Yet he goes in front of a judge twice. He testifies on cross-examination with Schoenhorn, read him the rights. He signed the form right at 1:20. Judge Davos says, wait a second, I want to get the sequence of events. That's the way it happened. That's the way it happened. For real? We're going to countenance this trooper 2 different occasions affecting the structure of integrity that should go along with the prosecution of someone? It's not right. With the motor vehicle hearing decision, a couple of side points that I wanted to make here. First, page 38 of the appendix is where the instruction was asked for by 39 by Mr. Schoenhorn. I strongly submit that the defendant passed the field sobriety test. This was a close call. The video shows it. The expert, Dr. Guasdo, testified the tests were given by the trooper incorrectly. I mean, he doesn't even instruct on his own, taking the 8 steps and turning, doesn't draw a line in the pavement. So the defendant did, he substantially complied with those tests. The real issue is whether this court is comfortable with the state police coming in front of it and saying, we pass regulations, we don't follow them. If you're comfortable with that, affirm the conviction. The real issue is whether the court is comfortable with a trained trooper coming into trial and having the state argue he might have had a mistaken memory. Really? Really? When there's a video at 1:20 that shows us everything? I'd ask you to look at the Santos case, the Harris case. Video was relied upon by our state Supreme Court, the United States Supreme Court, to make sure that justice took place. These evidentiary rulings were harmful, prejudiced, and changed the outcome of an otherwise close case. Thank you. Can't hear you, Judge. Judge, you're muted.
Sorry. Thank you both for your arguments this morning. We'll take the matter under advisement, and hopefully we'll see you in the real courtroom soon.
Thank you, Your Honor. Thank you, Your Honors.